Hi, this is Business Law and Ethics, Tort Law, Chapter 3, Part 1. In tort law, the learning objectives for this chapter or part of this chapter describe the role of tort law as distinct from criminal or contract law. So you can take a look at the definitions of criminal and contract and compare it to tort. Identify remedies awarded to redress torts, the elements of tort, explain vicarious liability, indicating when it may be imposed, negligence act, and the importance of tort law for business. So let's get right into the definition of tort. Tort is committed when one person causes injury to another, harming his person, property, or reputation. A social or civil wrong that gives rise to the right to sue and to seek one of several remedies, right? General or punitive damages or injunction. Now let's take a look at the nature of torts. A tort has usually been committed when an intentional or careless act harms another. Injured party may sue for redress, being the plaintiff in this case. Tort law compensates victims, acts as a deterrent, and educates society. And continue on the nature of torts. Crimes are social wrongs that affect society as a whole. Prosecution for such acts is carried out by the state or the government. Defendant will be charged, not sued, and focus is to punish the wrongdoer. Wrongful conduct is often both a crime and a tort. Tortious activity is inherently wrongful conduct. Continuing on the tort or the nature of torts. A tort is considered always as a private matter. So when many crimes, the victim has a right to sue for tort, even if the prosecution results is in acquittal. Easier to successfully sue for tort as standard of proof in tort law is based on a balance of probabilities. Torts versus crimes. Wrongful conduct is often both a crime and a tort. Most of the torts have criminal conduct counterpart. Mistake there. Most of the torts have a criminal conduct counterpart. Easier to successfully sue for tort because of the standard of proof. A tort is a balance of probabilities, and crime, not a balance of probabilities. It's a beyond reasonable doubt. Now, the importance in business for when we talk about torts judgments are expensive. There's a huge financial impact, and the torts judgments are public relations nightmares. So can do irreparable damage to the business's reputation one way or the other. The importance of torts in business. When harm is suffered by the business due to act or omissions of others and no breach of contract involved, there is a remedy for it in tort. So the breach of contract may not stem from an act that is inherently wrong, but the breach entitles the victim to a remedy. So the question is how a business can mitigate the risk of a tort judgment. If you look at categories of tortious activities, you certainly have the intentional or deliberate, or unintentional or careless, which is negligent act anyway. So these are remedies. The remedies certainly differ here. You can just attest to knowing which one will be more than the other. The damages, most cases it's monetary. General pain and suffering for a future lost wage or wages. Special, it would reimburse the litigant for expenses or costs incurred before a trial. Punitive, not to compensate the victim, but rather to punish the wrongdoer. So the Supreme Court of Canada has placed an upper limit on non-pecuniary, non-monetary losses. Sits in the $350,000 range. Canada is certainly not like other countries that surround us. Court can also order the return of property or grant an injunction. Now, we talked about vicarious liability. Let's take a closer look at vicarious liability. Business can't be held responsible or liable for injuries that result from the actions of their employees, independent contractors who provide services in connection with the business, and limited to torts committed while on employment duties. So an employer can be held vicariously liable for the tortious act an employee commits while at work. Yes. So this liability is limited to torts committed while carrying out employment duties. So for an example, let's say Christina hires a new employee, a truck driver named Joe, to deliver her goods to various retail stores. While backing into a loading dock, Joe hits a parked car belonging to a customer. Christina can be held vicariously liable for the damages since Joe was working at the time of the incident. Now, elements of tort. The elements of tort must be proved. Wrongful act plus causation plus quantifiable harm equals tort. So a negligent act or a negligence act is a failure to behave with the level of care that someone of ordinary prudence would have exercised under the same circumstances. Joint liability and contributory negligence. So let's say two engineers who worked on a project. If both are held liable for the harm to the plaintiff, the Negligence Act provides that the plaintiff is entitled to recover the full amount of damages from either of them. Example, if a construction worker or a construction site inspector is injured by a falling object was wearing a helmet, particularly if he was told that he must wear head protection when visiting the construction site, he may be found to have contributed to his injuries by failing to make reasonable care of his own safety, right? And might not be able to require 100% damages, right? So in other words, you need to follow the rules. And question for discussion, you can take a look at this. Is it possible for wrongful conduct to be both a tort and a crime? We answered that, right? And also, is it possible for a person who engaged in wrongful conduct to be prosecuted criminally and then to be subject to a civil lawsuit to compensate the victim for the injuries suffered, regardless whether the criminal charges result in a conviction or acquittal? So is it possible for wrongful conduct to be both a tort and a crime? Yes. In a criminal action, the standard is beyond a reasonable doubt, meaning that the criminal court, the case against the defendant, must be completely proven, uncontroversial, no doubt remaining about the fact that the defendant committed the crime or the defendant must be acquitted. This is a much higher standard required comparatively with a civil action, considering that the burden of proof in the civil case is the preponderance of the evidence, which is much less than required in a criminal case. So, a civil jury can be fined by a preponderance of the evidence that the defendant wrong act conduct results in civil liability. So, just to give you a little definition, preponderance means the quality or fact of being greater in number, quantity, or importance, right? So the preponderance of women among older people, let's say. So that's what that means in this case, right? If we look at that, civil jury can find by a preponderance of the evidence that the defendant wrong act results in civil liability. In other words, quality or fact of being greater in number, quantity, or in this case a lot, is importance. That is the chapter. Thank you.